shareholder agreements and partnership agreements. This short clip should give you some of the practical advice that you need in order to avoid shareholder and partnership disputes. My name is Susan Singleton. I'm an English solicitor, and I have never had so many disputes as we have had in the last 12 months because people have not agreed things in writing. My firm is Singleton Solicitors. We do a lot of shareholder and company law disputes. Website singlelaw.com. So what can you do? Some essential pieces of guidance now for people who just cannot get things in writing and ought to. First of all, have an agreement. You feel you can't afford a lawyer. Fine, have something in writing. Why, time and again, do we have disputes where the parties have nothing in writing? They couldn't even spend 5 minutes writing down what their profit shares would be. It's not very hard. So if you're forming a limited company, you should have a shareholder agreement. Now, you might have a small percentage of the shares. That gives you very little power, believe it or not. So give yourself more power. Minority protection for shareholders is a key part of what we put into shareholders' agreements when we're acting for the minority shareholder. You do have some rights under the Companies Act 2006, and indeed I had a big case last year on this, which we won. However, you're much better off with a written shareholders' agreement with minority protection. That would cover things like the percentage of the shares that you own, whether that percentage could be reduced, diluted, what happens if one of you dies or wants to leave, how much effort will each put into the arrangement. There might be sweat equity, there might be money put in. Lots of times shareholders fall out because one is working harder than the other. Get it in writing. You might love your partner or fellow shareholder. You might have gone to school with them 50 years ago. You might not be able to envisage that you could ever fall out. But believe it or not, we've seen it time and again. The bosom buddies, the lovers, the very old friends, they fall out. And what do they fall back on? Often nothing. So they're litigating. They're spending 25 times what they'd have spent on half an hour with a lawyer checking things out beforehand. Anyway, I don't mind picking up the pieces. But if you have pieces to pick up, come here, because I'll keep you away from court and I'll resolve the dispute. But get it in writing first, and then you won't be coming to me. You'll be grateful. You'll be spared it. So we've got the Companies Act, some protection, get minority protection in there, have a full contract that's signed. You might need to change the company's Articles of Association too, because they must reflect the shareholders' agreement. So you would have an obligation to register that at Companies House. If you're not forming a limited company, you're probably going into partnership together. That's probably a standard partnership. It's the Partnership Act 1890 that applies. In that situation, you can give notice to terminate a partnership. However, it's much better again to have it set out in writing. It will do you so much good later if there's a written agreement about who does what, who can terminate, etc. They're not hard things to draw up at all. You need to cover eventualities. If you've got a 50-50 arrangement, particularly going back to shareholders' agreements now, you may need to have situations where you can resolve a deadlock. And last of all, as I'm keeping this brief, if you have got a company that you own jointly with a 50% shareholder, be aware that under the Companies Act, you can not terminate a directorship unless more than 50% of the shareholders agree. So the person with 51% can always sack their co-director, whatever the contract says in English law. I do lots of international contracts. Been to Iran, Dubai, Switzerland this year on business. However, here we're talking about English law. And always make sure the contract says which country's laws apply. Now that's just a little flavour or taste for the types of issues that you might want to cover. If you come to wanting to sell the business, then again, have it in writing, do your due diligence, and come ideally to expert lawyers who deal with sales of a business. And I'm actually the author of this book, Bezic and Wine, which is about buying and selling businesses. And that's helps you if you're involved in a sale. But principally, there'll be many fewer disputes if you get it in writing. Now, if you need legal advice, amongst many other firms, you could come to me. I'm Susan Singleton. My firm in London is called Singleton's Solicitors. My website is singlelaw.com. My email address is susan@singlelaw.com. I give about 50 legal talks a year as well, so by all means book a course, singlelaw.com. And also written 30 law books, so I'm quite easy to find. Good luck with the arrangements. Do get it in writing. That's my tip for today. Have written contracts. There, end of the lesson.